So first of all, the rule against bias is the first principle of natural justice is the rules against the bias. It means that the deciding authority must be impartial and neutral. It is based on three maxims. That is, no man shall be the judge in his own case, and the justice should not only be done, but manifestly and undoubtedly be seen to be done, and judge like Kaiser's wife should be above suspicion. Now, what this principle says, it explained that it is a well settled principle of law that justice should not only be done but must be appear to be done. Justice can never be seen to be done. If a man acts as a judge in his own case or is himself interested in its outcome, this principle is applicable not only to judicial proceedings but also to quasi-judicials as well as administrative proceedings. If the judge is subject to bias in favor of or against either party to the dispute or is in a position to that a bias can be assumed, he is disqualified to act as a judge in that particular case and the proceedings will be vitiated. Now, what are the types of bias? Because bias may be of different kinds, that is, in the form of pecuniary bias, personal bias, subject bias, departmental bias, and or policy bias. So now what are these five heads? So first head is pecuniary bias. As regards the pecuniary bias, the least pecuniary interest in the subject matter of litigation will disqualify any person from acting as a judge. According to Griffith and Street, a pecuniary interest, however slight, will disqualify even though it is not proved that the decision is in any way affected by it. In the case of Manaklal versus Premchand, it was observed that it is obvious that pecuniary interest, however small it may be in a subject matter of the proceedings, would wholly disqualify a member from acting as a judge. Again, in the case of Jijabhoy versus Assistant Collector, the bench was reconstituted on the objection that one of the members of the bench was member of the cooperative society for which the land in dispute had been acquired. The second main important kind of bias is personal bias. Personal bias arises in a number of circumstances involving a certain relationship equation between the deciding authority and the parties which inclined him unfavorably or otherwise on the side of one of the parties before him. Here, a judge may be a relative, a judge may be a friend, or a judge may be a business associate of any of party. He may have some personal grudge against him, enmity or grievance or professional rivalry against such party. And in view of these factors, there is every likelihood that the judge may be biased towards the one party or prejudicial towards the other party. So this is the personal bias. Let me see with the help of one of the case law. In the case of Mineral Development Limited versus State of Bihar. In this case, the petitioners were granted mining license for 99 years in the year 1947, but the ministers who had political rivalry with the petitioners cancelled the license. The challenge was accepted by the court and it was held that there was personal bias against the petitioners and the ministers was disqualified from taking any action against the petitioners. Now the third bias is subject matter bias. This may arises when the judge has a general interest in the subject matter of the proceedings. According to the Griffith and Street, only fairly will be the bias invalidate proceedings. A mere general interest in the general object to be pursued would not disqualified as a judge from deciding the matter, and there must be some direct connection with the litigation of the subject matter. Only in that case it can be said that the subject matter bias arises in a very particular proceedings. Third is departmental bias. Departmental bias is inherent in administrative process. If it is not checked, it will negate the concept of fairness in administrative process. In the case of state of UP versus RS Sodhi, the question was whether the state police should investigate into the alleged fake encounters. Allegations were leveled against the local police. According to the Supreme Court, investigation into the matter by independent agency was desirable, and accordingly the court directed CBI to investigate into the allegation. The last form of bias is policy bias. Sometimes it happens that the ministers or the officers concerned may announce beforehand the general policy which he intends to follow. The question is whether such a statement would disqualify him from acting as a deciding authority on the ground that this indicates his partiality to the issue in disputes. So, according to Professor Wade, ministerial or departmental policy cannot be regarded as a disqualifying bias.